We got a startling and breaking news story to start this week. A big loss for the Trump administration. The full panel of the Court of Appeals for D.C. has ruled against the Trump administration 7-4. The 4 judges, 3 of them being Trump appointees. I'll talk about that next. But the 7 majority found that both Gwen Wilcox and Cathy Harris need to be immediately reinstated into their positions. At one, the National Labor Relations Board, the other at the Merit Protection Service Board, because they were unconstitutionally and illegally fired by Donald Trump because he claims he was exercising his Article 2 power. But these are bipartisan, congressionally created bodies, National Labor Relations Board and Merit Service Protection Board, to protect workers and federal workers. And he's not allowed to do that under a long line of cases going back 90 years called Humphrey's Executor. That case is still good law, is still what the Supreme Court relies on, and recently reaffirmed it in 2020 in a case called Celia Law. That's what the majority says. I'm going to break it down for you now about what happens next. Here's how we got here. These came up as individual cases. They were consolidated for appeal. The case of Gwen Wilcox before Amy Berman Jackson, the case of Cathy Harris in front of Raul Contreras, 2 judges at the trial court level in D.C. They ruled based on the same case law. It was a very similar order based on this law I just told you about, Humphrey's Executor, which says that if Congress creates a body and it doesn't exert too much executive power and has independent functionality, and they've created it in a bipartisan way for a purpose, the executive branch cannot fire any of the people on there unless it's for cause, unless it's for malfeasance or neglect or wrongful conduct. And Donald Trump doesn't argue in any of his papers that any of these people did anything wrong. He just doesn't like the color of their party, doesn't like their gender, doesn't want them there any longer. But that's not what the statute says in creating those 2 bodies. And if it's that kind of body, Humphrey's Executor, that case law I'm telling you about, says you can't just fire them without cause. He's saying I can fire them because that law that's been on the books since the 1930s is unconstitutional because I have the power, the ultimate power over the executive branch. Okay? That's not what the case law says. And so we have a constitutional crisis that's going to get resolved one way or the other by the United States Supreme Court. But for now, this is what, let me read to you from the order. The judges that joined in the order are Judge Srinivasan, who's the chief judge, Judge Millett, Judge Pillard, Judge Wilkins, Judge Childs, Judge Penn, and Judge Garcia. The ones in dissent are Henderson, Walker, and Rayo, and Katsas. 3 or 4 of them are Trump appointees. 2 of them were on the original panel that voted 2-1 to not reinstall them, not issue the stay, they were in favor of blocking the injunction from the trial court level that would have required these 2 people to go back to work. They said, well, no, we don't want to disrupt the status quo. It's extraordinary. The executive branch fired them. We shouldn't be rehiring them, like that. Here's what the majority decision has said that is now going up to the Supreme Court. Ordered that the motions for en banc reconsideration, that's the entirety of the group I just told you about, and vacatur be granted, that means vacating, and the government's motions for a stay pending appeal are denied. In other words, we're not going to stay our order. Get back to work, Ms. Harris and Ms. Wilcox, and they can litigate in the meantime, which means the Trump administration is going to have to run now to the Supreme Court to try to get an emergency stay. In Humphrey's Executor, which is from 1935, and another case called Weiner, from 1958. This is from the decision on page 2. The Supreme Court unanimously upheld removal restrictions for government officials on multi-member adjudicatory boards. While 2 laws governing removal restrictions for single heads of agencies exercising executive policymaking and enforcement powers have been held unconstitutional, see Celia Law case from 2020, the Supreme Court has repeatedly stated that it was not overturning the precedent established in Humphrey's Executor for multi-member adjudicatory bodies. That's what we have here, multi-member adjudicatory bodies. Instead, the Supreme Court has, in its own words, left that precedent in place, quoting from the Celia Law case from 2020, recognizing that Celia Law did not revisit prior decisions. Are you looking for something simple and delicious to add to your wellness routine? Look, I'm a honey guy instead of artificial sweeteners, so I put regular honey in my salad dressings and hot drinks. But then I found Manakura that put all other honey to shame. It has a certain creaminess and complexity of flavor that is unmatched, not to mention the health benefits. The best way to use Manakura is straight from the spoon, first thing in the morning, letting the creamy texture melt in your mouth and coat your throat. Manakura honey is rich, creamy, and the most delicious honey you've ever had. It's ethically produced by Manakura's master beekeepers in the remote forest of New Zealand. Manakura honey contains powerful nutrients to support immunity and gut health. The bees collect the nectar from the Manuka tea tree in New Zealand. The nectar is packed with bioactives, and the honey that is produced, well, it has 3 times more antioxidants and prebiotics than your average honey. A special antibacterial compound called MGO also comes from the nectar of the tea tree. Manakura third-party tests every single harvest for MGO and makes these test results available through their QR system. It's a game changer. And all you need is 1 heaped teaspoon each morning to get the most out of the amazing bioactives in Manuka. Additional usage through the day is completely fine, especially helping to cut out other sweeteners. It's a honey with superpowers. Now it's easier than ever to try Manakura honey. Head to manakura.com/legalaf to get $25 off the starter kit, which comes with an MGO 850 plus Manuka honey jar, 5 honey travel sticks, a wooden spoon, and a guidebook. That's manakura.com/legalaf for $25 off your starter kit. The Supreme Court has repeatedly told the courts of appeals to follow extant Supreme Court precedent on the books, unless and until the court itself changes it or overturns it. If a precedent of the Supreme Court has direct application in a case, lower courts should follow the case which directly controls, leaving to the Supreme Court the prerogative of overruling its own decisions. That's from a Supreme Court, Mallory versus Norfolk, 600 U.S. 122, 2023. The rule governs even if the lower court thinks the precedent is in tension with some other line of decisions. In other words, we don't have a choice. Supreme Court has directed courts of appeal to apply the precedent and let the Supreme Court fix it if there's a problem. And that's exactly what they did. The Supreme Court, they then go through the orders. They then go through the standards for blocking the order, which they're not going to do, and the request for the stay being denied. Judge Henderson, in a 1-paragraph dissent, because she had ruled, her ruling is what's being overturned here. She said, "We do the parties, especially a functioning executive branch, no favors by unnecessarily delaying Supreme Court review of this significant and surprisingly controversial aspect of Article II authority. Only the Supreme Court can decide the dispute, and in my opinion, the sooner the better." She thinks she was right, in other words, with her 2-1 decision. She thinks the appeal should have been taken directly to the United States Supreme Court and skip the en banc part. But look, it's a stronger case now on appeal with 7 judges. If you add in Judge Millett from the lower court, 8 different judges have looked at this and have said, Humphrey's executor controls, you can't fire these people without cause. You don't have cause, get back to work. I think it's a stronger case, and that's why they did it. Not to delay getting to the Supreme Court. Now, the road divides here. Technically, procedurally, it goes back to a 3-judge panel. I think it may be the existing 3-judge panel of Walker, Henderson, and Millett, and Obama, Bush, and Trump appointee. And they have to make a decision about the legality of what happened, given the new precedent that's been, or the extension of the precedent that's been set here. We know what they're going to do. It's going to be another 2-1 against Wilcox and Harris. Then, but right now, without waiting for that, procedure to happen. The Trump administration on the losing end of this can take an emergency appeal, first stop, Chief Justice Roberts, to decide whether the stay is going to be given. We just saw recently, there's a series of things sitting with the Trump with the Supreme Court about stays. Sometimes the Supreme Court moves fast and issues stays or doesn't issue stays, like they just issued a stay to effectively approve Trump cutting off $60 million worth of teacher funding through teacher grants unilaterally. They just did that a couple of days ago with Amy Coney Barrett joining the majority. But there's other things they're sitting on, like birthright citizenship being denied by executive order. They haven't ruled on that. We're still waiting around for whether Judge Boasberg on the Alien Enemies Act case, whether he's right or wrong to find that Trump did not properly exercise his powers under the war powers to deport people without due process to El Salvador. Still sitting with the United States Supreme Court. I mean, look, I could come back here in a few minutes and tell you they finally ruled. But these things sort of pile up at the Supreme Court, usually because they either can't get their votes together or they really are not that interested in moving quickly on something. They'll just let it go through full appeal. Here, there's going to be this application. We'll follow it. If I was making a prediction, it's hard to predict with the Supreme Court lately. They're so tied up in knots with each other and themselves. We're going to find out what their view is on this Humphreys executor law and whether they think the firing can happen. I think the 4 votes on the Supreme Court that will find that Trump can use his Article 2 powers to fire whoever he wants in the executive branch, regardless of how it was created, I think exists. It's Alito, Thomas, Kavanaugh, and Gorsuch. The question is going to be, again, Amy Coney Barrett, and this is Amy Coney Barrett's court. We're just living in it, or John Roberts. If they side with the other 3, it's going to be 5-4 to affirm this decision and to put Wilcox and Harris back in their job. If they slide over, if one of the 2 slide over to the other side, they're gonna block this again, and Wilcox and Harris can unpack their boxes again because they're not going to work. And I'll continue to follow it right here on the MeidasTouch Network and Legal AF. So until my next reporting, this is Michael Popok. In collaboration with the MeidasTouch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.